Well, mining magnate Mzee Khumalo has lost his protracted court case against the South African Reserve Bank decision to attach his assets and shares worth R1 billion for breaching exchange control regulations. Joining us now to talk about the implications for South Africans is Aneria Bouwer, who is tax practice partner at Bowman's. Good afternoon to you, Aneria. Just remind us what this case was about. It's quite a while, several years.
It's been quite a while, and unfortunately, although there were 3 reported cases, they do not provide a lot of information regarding exactly what happened. What we do know is that Mr. Khumalo entered into a BE transaction where he bought shares in Harmony Gold. He borrowed 760 million rand from Deutsche Bank, and then he pledged certain shares to Deutsche as security. Now, according to newspaper articles, he made a very nice profit on the transaction, so it's not clear whether he defaulted on the loan to Deutsche or what the position was. But there obviously was some other issue from an exchange control perspective and in respect of the repayment of the loan or the pledging of the shares. They were, in the court cases, they only mentioned that there were allegations of fraud in respect of the exchange control, the pledging of the shares. What happened then is Mr. Khumalo then went to court. That was already, he first went to court a couple of years ago in 2009, where he alleged that the regulation in terms whereof the assets were attached was invalid. The Pretoria High Court agreed with him, but then the matter went on appeal to the Supreme Court of Appeal in 2010, and they found against him, so they held that the regulation was valid and that the attachment could proceed. He then applied again to the High Court in Pretoria, and he wanted the court to consider whether the decision to forfeit the assets to the state was valid. He wanted them to declare it, the notice and the order of forfeiture invalid, and he also wanted them to declare the regulations to be unconstitutional.
Well, Aneria, let's quickly chat about the foreign exchange rules in South Africa from 2011 up until now. It's about 6 years that have gone past. Have they changed at all?
They have changed. There are, every couple of years in the budget speech, some relaxations are announced. What has changed substantially last year was that the rules are now accessible to the general public. Before that, it was essentially a private affair between the Reserve Bank and the authorized dealers, so the commercial banks who enforce exchange control. What has now changed from a policy perspective is that, in principle, individuals or businesses can now also access the rules. From a relaxation perspective, there hasn't been much. So you still need, if you're a South African resident, you still need exchange control approval in order to remit assets offshore.
Thank you so much for joining us, Aneria Bouwer. She's the tax practice partner at Bowman's.